Immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now so that I can answer your questions. Today, I really want to focus on your questions, but I did want to answer one question that comes up very often, especially in the consultations, and that is, okay, you've overstayed your visa. Can an employer then apply for your work permit? The short answer to that is no. Thank you so much. I appreciate the compliments. Thanks so much. Yes, today is a good, energizing day for me. So thank you for bringing more sunshine to me with those compliments. Uh, so the short answer is no, an employer cannot get your work permit for you after you've overstayed. My next response to this is usually if an employer has promised you a work permit after you've overstayed, or they cause you to overstay while promising you a work permit and they put you to work for them, then this might be fraud and you may be the victim of trafficking by fraud. We just got an approval for one of our clients based on this one promise alone. The, my client was here, my client was willing to leave the country, but was told by the employer that, hey, if you stay, come work for me, guess what? I'll get your papers and it's all legal. Get the papers, legal, everything. And when it came down to it, when it came down to applying, the employer acted as if they never knew what that promise was, that they never said that. They instead suggested my client pursue fraudulent ways to get their papers and their work permit. My client, though, did the right thing, and as soon as this happened, left the work. And I understand sometimes you may not have a choice or the flexibility to just get up and go. But my client, well, actually, my client got injured, so I had no choice but to leave, and the employer cared nothing about what happened to my client. My client could not work after the injury, left because then, with the failure to file for papers, then being injured, it was just too much. And my client now has status because of this fraudulent promise. So if you're in that situation, give me a call because you can qualify for what's called T status based on this. And a lot of employers are not being held accountable. So they get away with doing these things. They get cheap or free labor, or they put immigrants in positions where they work strenuously, or they work in environments that are unsafe because they feel like they don't have any choice, and the employer does it because they feel as if they can get away with it with certain immigrants, those who have overstayed, those who have came into the country without inspection, and so they tend to be very the ones that are targeted because of these facts. So I just wanted to bring this to your attention, right? Overstay means you cannot apply for the work permit through an employer. I mean, there are rare, I wouldn't say rare, but there are exceptions. And for example, one of the exceptions is, and this one doesn't even allow you to stay here. It doesn't allow you to get the work permit. So it wouldn't even count as getting the work permit through an employer, by the way. But if you're here, you have a citizen or resident parent, and the employer agrees to sponsor you, you could get a special forgiveness for the overstay, but travel back to your country for the final interview to get your employment-based green card. So as you can see, it's a sort of last resort option. And, most people would rather be here and get their green card or get their work permit than have to leave and face the risk of being outside of the country after overstaying or being here without status. All right, so now I'm going to jump straight into questions. I want to spend the rest of the time answering some questions here. Hey, do you charge for consultation? So absolutely, we charge. Just go ahead, call the office, and you can schedule or go to the link in the profile to schedule. It's 150. Hello, hi there, Erin. It's so nice to see you. I want to concern about husband and son case from India. I'm here in the USA. So, give us, if you are in need of legal advice and you don't already have an attorney, give us a call and let's talk. Um, Otherwise, always be sure to talk to your attorney. Your attorney is there to assist you. So call your attorney because they know your case best. Hello, I have a master hearing on the 25th of April. Is it possible for me to go to immigration court without a lawyer for this first appointment? So I often, sometimes you don't have a choice. The 25th is right around the corner, and it may be very hard to get an attorney to show up in such a short period of time. Um, I encourage you, though, try your best to get an attorney to go with you, because what I do find is a lot of people that go to the court hearing without a lawyer, they get a chance. So sometimes the judge then continues the case, schedules it out for 6 months to another year out, and gives you the chance to get a lawyer. The judge sometimes will say, "Listen, if you don't come back with a lawyer, we're going to move forward with your case," and that can lead to bad consequences for you without having a lawyer, because a lawyer knows how to navigate the court proceedings and what best to bring forth to the court regarding your defenses to deportation. So important that you find a lawyer. It's not guaranteed though that they're going to give you that chance. If you go to your first master calendar hearing, what usually happens is they will go ahead and they will you basically answer to the charges in your notice to appear. Once you confirm that, then the judge, if there are any motions or any sort of defenses, like if you're claiming asylum, withholding of removal, cancellation of removal, those kinds of defenses to deportation, the judge will accept it at the master calendar hearing and then move forward with scheduling an individual hearing, which is sort of like a final trial. That's usually scheduled. Right now, it can be even years from now. Some are being scheduled 2, 3 years from the date of your master calendar hearing. But the first hearing is usually about answering to the charges in the notice to appear. When I say charges, it means, what they usually put the reason you're being issued deportation, a notice to appear for deportation. They'll put that in. I just refer to it as the charges. And then you have to state then how you're going to respond to that as a defense. So get an attorney, but if you can't, you'd have to go. Don't miss your court hearing, because if you miss your court hearing, they can deport you in your absence, which is very bad. Or you can miss out on some important aspects of your case. If you don't have any choice at all, go and see if you're able to get a chance to get an attorney. Stating your efforts to get an attorney. My sister's husband hit her and she wanted to move out and leave him, but she only have a work permit. What's her best option? So if this husband is a U.S. citizen or a legal permanent resident, VAWA. That's going to be the best option here. And me and my team, we're good at that. So give us a call. We'll take good care of her. So let's start with a consultation, make sure she qualifies for VAWA, and get going. Can you get now, one thing I want to say, why it's important here. So it says she only has a work permit. With the VAWA, she can transfer her case from the marriage-based process to VAWA, meaning her work permit will stay valid, everything will stay valid, and she doesn't have to worry about it being revoked or terminated, and her case can move forward to the green card. So she can just transfer from one process to the other instead of having to start all over again. So that's why it's important to jump on it now. Can you get a work authorization before a prima facie? So yes, that's possible. It's not common because a prima facie is usually issued anywhere from 3 to 6 months after they've done a review after filing, but it's possible. Does my credibility and employment industry is heavily regulated and monitored have any impact on whether boyfriend can visit from another country? I believe his chances of being approved are low. So no, especially seeing that this is not even a marriage, but it's down to your boyfriend getting a visa is really down to his qualifications and not yours. Are unmarried over 21-year-old stepchildren eligible for a petition? It depends. If you married the stepchild's parent before that stepchild turned 18, you can petition for them, but it's still going to be a 5 to 7 year process. If that marriage took place before their 18, after their 18th birthday, then no, you would not be able to qualify to petition for them as step parents. And even if you did, they're 21 or over, so it will be a long process. And overstaying would put a bigger wrench in the process. Why is that the only way to get a PR is to marry an American citizen? If you don't have a family here, you got here with a student visa, you want to stay after school. So I understand your frustration, but this is a misconception. The marriage to a U.S. citizen is not the only way to get your permanent residence. It's a more common way, but it's not the only way. Of course, with every single type path to permanent residence, which is a green card, you have to qualify for something. And to be able to qualify for other ways, you just have to qualify. And it depends on what your particular circumstances are. So, in your case, if you are here with a student visa and you want to stay after school, then some people, because they think that marriage is the only way, they may look for a spouse. They may spend a lot of time looking for a spouse because they think that's the only way. In your case, when you have a student visa, you can put your efforts into finding an employer who's maybe recruiting, who is willing or known for petitioning for students out of the program that you're coming out of. As a law firm, we don't do placements, but that's just one of the ways you can do it through an employer. It doesn't always have to be through marriage. What if the marriage is real, but the applicant name is not on any bill? Then you're going to have to find, when you're married, I believe when you're married, you are going to have something to show that you are in a meaningful marriage. When I am representing my clients, I've never had a problem with this because when my clients are in a meaningful marriage, they've never had to look for, had a problem pulling documents that shows their marriage, shows that they're building a life together and a future together. So bills are not the only type of evidence to show, right? If you don't have joint bills, but you have a joint bank account, maybe you have a joint lease, maybe you have friends and family that know are involved, have a good relationship with you and your spouse. All of these count as well. Maybe you have phone records. Maybe you have a joint phone bill. Maybe you have, other on even non-conventional types of evidence. Say you travel a lot together, so you have itineraries with your names on the itineraries, plane tickets, traveling in around the country. So it just depends on the marriage, but there's always going to be something that you can show that you're building a meaningful marriage together. So bills, not the only thing. My son turned 17 today. His aunt took him to the States from he was 12, but no papers as yet. What should I do because she doesn't talk to me anymore? So if in this case, there are a number of options here. If your son is 17, the aunt took him. Is in some cases I've seen where this I'm not saying that's the case here, but I've seen where the aunt mistreats the child, puts them to work, doesn't follow through on promises, and maybe the motive was to get them there to watch the younger kids or to do work around the house or errands around the house, then that could be a form of labor trafficking. If at the same time you gave custody of your son to your sibling, then that could result in what's called SIJS, whereas your son is a special immigrant and can get status and a path to green card that way. So it just depends on what the situation is. That's where it's so important to schedule time to speak. I don't know if your son is in distress, but let's talk to find out what the situation is. I'm 43 this year, and I found out when my father died in 2022 that my petition was approved and nothing more was done. What are my options? I have siblings there. So there is, now it depends on when the approval happened. If the approval happened before your father passed, then there's what's called, usually the petition is no longer valid after the death of a petitioner. However, there are instances where they can do humanitarian reinstatement if the if the approval was before the death, and there is someone else that's willing to step in to do the financial affidavit. But to determine whether that would work in your case, because this is very discretionary, we have to find out more facts from you. Is it possible for the U.S. citizen mother to file for her adult son and granddaughter who have overstayed? You can petition, but it's not going to be a process where your son is going to have a straightforward, very short, painless process. Your adult son, who's I'm assuming is 21 or over, is going to be looking at 5 to 7 years. And that's if he's unmarried. If he's married, then you're looking at about 12 years. And then after that, because of the overstay, they will have to require him to apply for forgiveness to go back. If that forgiveness is granted for the overstay, then to do the final interview at the embassy in his country. So it's not an immediate solution. It's definitely not a fast solution, but it is a last resort solution. What I do say is if there's nothing, no other option, then still create this option for your son and have it as a plan B in case nothing else comes up. Maybe in 5 to 7 years, that could be the option if nothing else materializes. I'm in Philadelphia. How can I get in touch with you? We are a phone call away. So if you call the number 561, I'm going to go ahead and I'm going to put my number in the comments. So 561-405 4889. You can call that number or go to the link in the profile. And as soon as you click on the link, you will see buttons. You can schedule your own appointment without calling, and that will get you on my schedule or on Attorney Bria's schedule. Attorney Bria works with me as well. Or you can go to the website, which there's a button for the website. And when you go there, just look on the website, you'll see the phone number and you can click to call. Do you also assist with visitors visas? So it depends. So I have clients who have visitors visas who've come here, maybe overstayed, or they've come here and they're applying for adjustment of status, but it is not one of our areas. We don't help anybody to apply for visitors visas right now. So we mostly focus on helping clients to get work permits here in the US and they're permanent residents. So all our solutions and our energy is usually towards those goals. Petition for alien relative case was approved in November 2019, but I haven't heard anything else. What do I need to do to get my petition moving? It may be the wait list you're on. Some wait lists right now are 5 to 7 years. And I have a feeling you might be on that wait list. It's where you're waiting for your priority date to become current. If you look at the petition, you'll see the priority date. And then you have to look at the national interest waiver to be able to sorry, not national interest waiver. You have to look at the visa bulletin to be able to see when your date, how long it's gonna take you. All right, so let me go here. I'm on TikTok and I'm gonna answer some questions. So I'm going from one platform to the other, and I'm getting to as many questions as possible. I'm U.S. citizen. I applied for I-130 for my wife 12 months ago, and the case is not moving. It's something wrong. So I wouldn't be able to know if anything is wrong. However, what I would say is it is taking about 9 to 12 months. After getting documentarily qualified by NVC, when will I get my interview scheduled in Jerusalem? So I'm seeing the average wait time across the board is about 1.5 to 2 years. It might change though, just depending on where you are, might even be longer. So that, it really depends on the particular embassy. Employment-based I-551. Okay, so that's not. How long does it take to hear back on a decision of a VAWA application? So if you just filed, I'd say 2 to 4 weeks. And then, it depends on what type of process you're pursuing. Usually what we do is we apply for the VAWA petition along with the work permit, a travel document, and the green card application at the same time. So about 8 months later, the work permit comes with the travel document. And then about 2 years, the VAWA approval comes in, and then they move it to the green card stage. So within 2.5 to 3 years, you'll get the green card. Where are you located? So we're in Boca Raton, Florida. We're also located in Delray Beach, Florida. Even though we're in Florida, we have our clients all over the country. So not only in Florida, but nationwide. My sister is doing a DACA trip to Mexico. It's a group study. Are these real? So yes, so DACA, as long as they applied for the travel advance parole, have to make sure DACA does not, if she leaves the country and has DACA but does not have the permission to travel, she can find herself stuck. But if she has advanced parole, she's fine. If my F1 visa expired, but I am not done with my program, my I-20 is still valid. So yes, so now the I-20 doesn't give you immigration status, and it depends on the facts here. So I'd have to understand what's going on to be able to advise. After your 180 countdown, how soon can I put in application for a work permit? So after 150 days, then you can apply. And then at the 180-day mark, which is 30 days after 150, you can get the work permit. How long after VAWA with domestic violence application does it get approved? So it gets approved about 2.5 years later. However, one of the best things about VAWA is that it allows my clients to apply for a work permit in most cases before the approval. So at around the 8-month mark after filing, they get their work permit, which is 5 years right now, and their travel document, and then they can wait in a more secure spot, being able to work and being able to do things for themselves. They would be able to wait with that work permit until the VAWA can be approved and it moves on to the green card. Can someone who came illegally and has been petitioned for 11 years get a work permit? So I'm not sure what this means, what has been petitioned. So being petitioned, meaning somebody applied for you to get your papers, is not going to allow you to get the work permit alone. You have to qualify and some other way. You have to be, let's see, you have to be within a year to claim asylum. So with the asylum, you have to make sure that when you're applying, that you apply within 1 year of your entry. You should not be applying after 1 year because that means you'll get denied for a late filing. So someone here is in the chat is giving wrong information. So I just want to, guys, listen to me. Don't listen to other people that are, playing community lawyers in here, because that's where it gets dangerous, and I don't want to endorse that. So someone says you can't request a work permit until minimum 180 days. Wrong. You can apply for the work permit after applying for asylum at 150 days, and then they will issue the work permit at the 180th day. If you should not be waiting 100, you shouldn't be waiting 6 months to get just to apply for the work permit. You will set yourself back. So it's 150 days, which is roughly 5 months. I have a friend who needs their DS2 2019 status to adjust their status. How could she go about it? So I'm not sure. Now, with the DS 2019, that usually is related to the J1 visa and usually states whether the 2-year foreign residency requirement applies here. So it might be an issue with that, but your friend needs to do a consultation. Can you share more more on the work visa and the requirements? So there's not just one work visa, there are multiple, and it depends on your qualifications. But most importantly, it depends on the employer's ability to petition for you. That's the most important one. There is one that's called a national interest waiver if you have an advanced degree or exceptional ability. Then you can possibly apply for your own green card, but you still have to make sure that when you've overstayed, it will not work in this case. I'm 26 years old. I did not register for selective services. Can I apply for naturalization? It's possible, but we'd have to then state why is it that you didn't apply for selective service, to make a case that it wasn't intentional. How long to bring my brother from Romania? So siblings, petitioning for siblings is about minimum 14 years. My sister, as a U.S. citizen, is it faster if I apply for my sibling or if my green card holder parent apply? Green card holder parent applying is faster. U.S. citizens applying for their sibling is 14 years at minimum right now. What if you're married? Do you still have a chance in the U.S.? Yes, because marriage is not the only way to get your green card, but it depends on how you qualify. How long does it take for VAWA with DV to get approved? So I'd say 2.5 years. Thanks for the follow. Thanks, I appreciate it. How to apply for my mom green card? She's living out of the country. Be a U.S. citizen and be age 21 or older. That's how you can apply for your parent to get their permanent residence. I'm in the U.S. on B1, B2. Can my daughter, who is a citizen, adjust my status? Your daughter has to be 21 or older and a U.S. citizen to then apply for your green card. So yeah, it's possible. But make sure you schedule an appointment. That's going to be very important. As a US citizen, is it faster if I apply for? So I answered that. What about if the immigration judge require a police report, but I don't have it for asylum? So this is where you need to, this is more of a strategy question, and it's important to speak to your attorney about that to be able to figure out solutions or alternatives. Can you file a divorce in the US if you were married in Jamaica? I've seen, I've seen clients. I'm not personally involved in my clients' divorces, but I have gotten divorce decrees of my clients whose spouses live in another country. I've been a VAWA work permit for 10 years with 9 undocumented entries. Can I apply for green card? Schedule an appointment. This here 9 undocumented entries is it can, if it's what I'm thinking about, it can lead to a permanent bar, and you will need to make a good argument as to why they should forgive those undocumented or unlawful entries into the US. There may be waivers available, but it's really fact based. The waivers are available based on if you can show that your entries was related to the abuse or mistreatment, then they may forgive it in that instance. Can I apply for naturalization while waiting on my conditional green card to be removed? Yes, you can. And what sometimes happens is they'll schedule the interview for both the citizenship and the marriage, the green card renewal at the same time. Then they will put you through first the green card process. If they approve you there, then they move into the citizenship, and then you could walk out a US citizen or walk out with your scheduled swearing in ceremony. So it's possible, but they will not grant the citizenship, of course, until you get approved for the green card, and this might be removal of conditions. How long is it taking I-485 taking for them to make decision presently if you're married? So my cases are taking under a year. So I would say average is 10 months. My shortest is 5 months so far. So when doing marriage-based green card, do you have to pay for court fees? So I'm not sure. Marriage-based green card does not require payment of any court fees. I don't know if you have a particular concern, though. You need to talk to an attorney, and we're here for you. Go click on the link, schedule your appointment, and we can talk about that. All right, I have 1 minute before I have to head out. I'm going to answer some questions on YouTube quickly. My spouse, green card holder, we have been married 25 years and 3 kids. Can I apply for VAWA so he get problem or so I'm not sure. In reality, it has been only psychological violence and shouting words, but not blows. So it doesn't matter if you're being verbally, emotionally abused, this still qualifies. So give us a call. Let's hear what you have to say. It doesn't matter how long you've been with your spouse. What matters here is that you're going through that situation. I've approved VAWA, waiting for green card interview. Because my VAWA approved, so after marrying, can I file for my spouse U visa? All documents ready except marriage certificate. So you have 2 different things going on here. So the U visa, I'm not sure what's going on. Definitely schedule an appointment and let's talk. Overstayed E3 visa by 8 years with 2 children, 25 and 15. Now, can you help? Schedule an appointment. Let's talk because I have to get into a lot more detail about what happened here along the way to see if any of those alternative options can fit your needs. I originally came to the US for a master's and overstayed during COVID for more than 180 days, but got TPS. Can an employer sponsor me? So this one is a tricky question. So they did change the policies, and I would have to check the change in their policies because I know they did. I just have to look back at my records and look back at the publications that I have available to me. If you have TPS, though, it may be possible. If you overstayed and you accrued unlawful presence, there may be an issue. But this definitely calls for a consultation, because it's going to take a lot more to review your qualifications. But I can't say you don't qualify at all. You may very well qualify, depending on the changes or policies they have right now. Good afternoon, attorney. Please, can you approve good moral character if you have a criminal record? Yes, you can. How to apply emergency travel document? Go to the USCIS account. I believe go to tools, and there's an appointment. There's a section that refers you to, I believe, make appointments or make changes. Go to the tools, use the tools, and it will get you to the emergency travel document request. My son came to the US when he was 4 years old, tourist visa. He stayed over his tourist visa. He's 15 years old now. He has continuously stayed in the US for 11 years. Any option? Give us a call. This detail, believe it or not, is still far too little for me to be able to say if any options. When I'm in the consultations, I go through about 20 different options, and I have to ask questions to determine whether one of those will fit. So this is where the consultation is very important. Can someone with a pending I-751 invite one's parent on a visitor's visa? Yes, it's possible. You're still a green card holder, but keep in mind, those visitors are not going to get their those parents are not going to get their visitor's visa just by your invitation letter. They have to individually prove that they qualify for the visitor's visa themselves. All right, I have to head out. Thanks so much, everyone. Please save your questions for next time I'm on. Right now, we're very busy at the law firm, and we're getting our clients situated, making sure that our team is organized. So my usual schedule has not been steady, but I do try to spend at least three days a week, and I'm aiming to get back to the 5 days a week on here. So what you can do is follow me, subscribe, and then as soon as you see me come on, hop on with me and ask your questions, and I'll get to answering it. When can I book my consultation? Will I speak with you? Yes, you'll have the option. Go to the link in the profile on Instagram right now. You'll see me, so Attorney Sharifa, and you'll see Attorney Bria. You can choose. You can choose based on your availability or who you want to talk to. All right, our schedules are filling up, by the way. So if you want to talk, let's get to it now, okay? Go to my schedule, book, and you'll get on my calendar. You'll get on Attorney Bria's calendar right away, so you know you save your spot. Have a great day, everyone. Thanks so much. Bye-bye.